Good day, lovely viewers. We are here to talk about the updates in the Bryan Khoeburger case. And I've just thought of another one. Let me write it down. Motive. And so what we're really talking about is a lot of the applications that the defence has made and how the courts have ruled. Mostly they've rejected everything. So I'll give you a little quick update, or a little bit of the factual background, just in case you're not up to date with what's happening in this case. And then I'll let you know what the various applications that the defence has made recently. Most of them have been refused by the judge. So this is a really terrible case of 4 students from the University of Moscow in Idaho being murdered in their beds. This happened in 2023 in November, and it was terrible, horrific. I'm not going to go into much of the difficult details, but somebody came in and with a knife, we believe, murdered these 4 students. Now, there were actually 6, sorry, that's my dog. There were actually 6 students in the house at the time. This was 4 o'clock in the morning. The other 2 were not harmed, but one of the survivors actually came face to face with the murderer. And we know it's the murderer because of the time frame at which she saw this person. And then he was clad all in black from head to toe, and he had a mask over his face. It was like a ski mask, what in South Africa we would call a balaclava. So it covers his whole face, and only his eyes and his eyebrows were visible. And that becomes important because the eyewitness said that this person had bushy eyebrows. Oh, that's another thing that they had a fight over. So I've got about I don't know, 7 things here that the judge refused to help the defense on. Oh, I didn't write it down. And there was a couple of things that the prosecution said, well, there's not even going to be an issue. So anyway, so some person clad in black comes in, murders these 4 in the most heinous way, and we will just remember them. Ethan Chapin, Xana Conodal, Kaylee Gonzalez, and Madison Mogan. Beautiful young children, and young students, and we just send love and light to their families. So how the police found Bryan Khoeburger, he's a PhD student studying criminology in the next town over. How they found him was through genetic genealogy. So the genius who committed the murders, genius I say in sarcastically, left behind the knife sheath, and that was partly under one of the deceased bodies. And on the clip of the knife sheath was some DNA. And so what they did was they did genetic genealogy, which is basically they go to 23andMe or those kind of websites, and then they see, is there anybody that might be related to this person that have had their DNA put into the system, or related to anybody who's put into the system. And so they might be able to track a great uncle or something, and then through the magic of statistics they finally narrow it down, and then they find it's usually either the exact person or any of that same-sex sibling. So if there's 3 men in the family, it could be any 3 of those brothers. Anyway, so that's one of the methods that they use to track him, and they found who it is. And what happens with genetic genealogy is genetic genealogy itself doesn't prove who did the murder. It just points the police to the person, and then when they find the person, they get a search warrant and they actually test the person's DNA. So then they directly compare the person who they think it is with the evidence from the murder scene. And that direct comparison is the thing that they present in court, not the genetic genealogy of how they got to that person. So if you think about it, like when you were a kid in school and you had to do a maths problem, you couldn't just give the answer, but you had to show all your workings. And so this was one of the things that the defense had an issue with. They said, we don't want to know just what the answer was. We want to know who were all those relatives that they found, that they then tracked to this person. Now, genetic genealogy has been used in criminal cases for at least a decade, maybe even longer, and they've never, ever been required to show who the other members of the family are that led them to this particular suspect. And that makes sense, because say if it's maybe they found his cousin or something, why would that cousin need to be named in the court proceedings? It's anyway, the judge decided any of that working is not required to be shown, as it's never been required in any other case, because that cousin or whoever, the granddad, the great-granddad, had nothing to do with this case, and it would be an invasion of their privacy. And anyway, the genetic genealogy is just it's kind of like a roadmap that leads them to the person, and it's the direct comparison that is the thing that tells them they've got the right suspect. So the defense was making a big issue of the genetic genealogy, and they really made a big issue of it, but they seem to have dropped that issue. So that didn't get them anywhere. Then they wanted no reference to be made to bushy eyebrows, because the young lady who was in the house at the time and saw this black masked figure walking past, she may have not been sober, and so they're saying it's unreliable. And the judge said to them, she didn't say it was that man, she just said he had bushy eyebrows, and that was her observation right at the time, and she consistently said that, and she is allowed to say that. And the reason it becomes important, it's not because bushy eyebrows actually identifies him, but when you look at him, and there's this selfie that he took on the morning just after the murders had happened, when you see that selfie, you see he has got bushy eyebrows. And I think the relevance is, if the suspect did not have bushy eyebrows, then there might have been some kind of question. It's a tiny piece that adds to all the other pieces of evidence. And the judge said she was there, she saw this person going past, it was the right time frame, we can assume it was the killer because he went out through the door where the killer is known to have gone out. So defense struck out again. They didn't get bushy eyebrows axed from the case. Prosecution is allowed to talk about bushy eyebrows. Then the defense has brought up this idea of an alternative suspect. There was other DNA found in the house, but it was a student house, a party house. So they haven't discovered who the other DNA was from. It was from on a banister or something. And the judge said, well, firstly, it doesn't have anything to do with the offense, because just because somebody walked down the stairs and touched the banister doesn't mean they had anything to do with the murder. And obviously finding your guy's DNA on the clasp of the knife sheath left under one of the victims, that obviously relates to the murder. Somebody just having touched something in the house, that doesn't mean that they potentially were involved. Also, the judge said, even if there was somebody else there, so giving the defense the benefit of the doubt, all that would mean for the accused, Bryan Khoeburger, is that maybe he didn't act alone. It doesn't exonerate him. It doesn't set him free. It doesn't really help him in any way. And if they want an alternative suspect, then they need to, with really good cause, know who it is that they're accusing. And they don't know who that other male DNA was. And so they don't have somebody definitive, they didn't see somebody on camera in the area, anything like that. And so they can still raise the alternative suspect, and they keep mumbling that they might do, but there have to be some good faith reason behind it. Then the next thing the defense tried unsuccessfully to keep out was Bryan Khoeburger's Amazon history. So it was alleged that he bought the exact same type of knife off Amazon. Now, the police didn't recover the murder weapon, but they know from the knife sheath what knife it was, called a K-bomb knife. And so they've gone back, they got search warrants, and they went back and they had a look at his Amazon history. He bought a K-bar knife and a K-bar knife sheath and a K-bar and a knife sharpener about 8 months before the murder. And the prosecution says, well, this is important. We know he owned the type of knife that was used in this murder. It's important. And then something surprising that also came out was, now this hasn't gone to court yet. This is just the wrangling, the legal wrangling before we even get to court, as to what can be shown to the jury. So in the motions to suppress the Amazon history, we also learned that there was a search by Bryan Khoeburger for a replacement knife and a replacement knife sheath after the murder. So after the murder, Bryan was not able to produce his knife. Nobody knows where it went. Obviously, the prosecution theory is that he committed the murders, he drove home, and on his way home, he somehow disposed of the knife. And that's why he was looking for a replacement after the murders. So that's very important. And so the defense was arguing, and they were saying, well, Judge, this doesn't really prove anything. Firstly, it's a family account. And then the prosecution said, well, it might be a family account, but we've got records from Amazon that shows it was shipped to Bryan Khoeburger and received by Bryan Khoeburger. So you can't, although it's a family account and different people can use it, when it came to him selecting who it would be sent to, he selected himself. So that's clearly, that was him, not somebody else in the family. And jury can decide whether or not how probative that is. But then when the defense was saying, oh, but when you do searches, sometimes you get recommendations pop up. And so it's not necessarily that he was looking for a replacement after the fact. That could have just been the AI suggesting it. But the downfall in that argument is that not only did somebody look for a replacement, they placed it in the cart, like the shopping cart, and it was under Brian's name, not under the parent's name or the sister's name. So, and as the judge said to the lawyer, yes, Amazon might give you suggestions based on your past search history, but the human being has to click the button to make it appear in the cart. And that is what the prosecution has, appearing in the cart. So saying, oh, AI did it is not an excuse. So the judge, again, rejected the defense's motion to keep that information out. And so that, I don't know, to me, that's just really weird and creepy. That's a very important piece of evidence, I think. By itself, it doesn't mean anything, but when you add it together with everything else and the DNA link. Then there was the cell phone pings, okay? So there's cell phone data that shows him being quite near to the house where these people were killed. The defense was saying the science isn't as certain as the prosecution's expert is making it out to be, and their expert, apparently they wanted their expert in to contradict it, and the judge just said, look, this is kind of tried and tested information. The defense also tried to argue that the prosecution had more information regarding the cell phone location than they provided. And what happened actually turned out is that somebody from Verizon came and gave evidence to the judge, so the judge could decide this issue. What actually happened was, now Verizon keeps much more extensive records, but at the time when this murder occurred, they didn't keep such extensive records. So basically, the information that the prosecution said they had was all the information that Verizon provided at the time. So the defense tried to make it like the prosecution was hiding something, when it turned out that Verizon gave them everything they had, and prosecution turned all of that over to the defense. So the defense was saying that the prosecution evidence was unreliable because they were hiding, they were only cherry picking a certain information. But the guy from Verizon said, no, actually, they've given you everything that there is. So the court said that cell phone history can come in. The other thing about the cell phone history, and why this is going to be really important in the case, is that it showed on the night of the murders, Bryan Khoeburger leaving where he stayed in this off-campus apartment, and then the phone goes dark. Basically, somebody has turned off that cell phone. And then there's some video footage of a car that may or may not have been his car. There's a bit of argument about that, circling around the house at the relevant time. And then after the murders had been committed, the car drives out, the cell phone is then switched back on, and you see he goes a very circuitous back route back to his apartment. So the defense has tried to explain this away. They've said Oh, he was out that night. He was driving around, but he was just driving around the back roads because he was stargazing. But it took them a year and a half to come up with this story, so it seems unlikely. If that was what he was doing, they would have said it straight away. But of course, jury's not going to find out that it took them a year and a half to come up with this. But the point really is, he was a criminology student, so he would have been trying to employ countermeasures so that the cops couldn't catch him. This is the argument of the prosecution. Obviously, he's presumed innocent until he's proven guilty. And one of the countermeasures would be you turn off your cell phone. And I would be really interested to find out how many other times did he ever turn off his cell phone? Let's see the 3 months before and the 3 months after. Was there ever a night, in the middle of the night or in the middle of the day, any time when he turned off his cell phone? Because most of us don't turn our cell phones off. And if you can show in that 6 months, the only day ever that he turned off his cell phone was when he was driving out of where he lived, and we see the video of his car driving out of there, cell phone is turned off, and then we see a car that looks like his. There's no number plate readers, so we're not 100% sure, but we see a car that looks like his circling round and round and round the house where they were killed. Phone still stays off, and then it switches back on when he's part way home on this really weird back route that took like an hour or 2 hours, whereas normally, if you took the normal route, it would only take 10 minutes to get home. So, yeah, there's that. Cell phone pings are allowed in, and the cell phone data of the phone being presumably switched off or not connecting to the network, that is allowed in as well. Defense tried to argue that it wasn't reliable, but their experts have shown to the judge that it is sufficiently reliable that they can. It's not a smoking gun, but it just, when you add everything together, it doesn't look good. The other thing that the defense wanted to keep out was the prosecution has got this video of Bryan Khoeburger in the car, and it's a police camera video, body cam video. He got stopped because he did some traffic violation, some minor traffic violation, and you can see from the body cam that's his car. So they're going to say that's the same car that's on the grainy CCTV video. And then when the policeman steps back, you can see, I think she was a lady, you can see on the camera the license plate. So it is identifying the car that they attributed to him. So the prosecution's going to put that in for the purpose of identifying the car and identifying that he was the owner of the car and the driver of that car around that area. But what it also shows is that he has an argument with the police officer who tells him he should be wearing his seatbelt, I believe, and then he argues about it, or some minor traffic infraction, and he argues about it, and he's quite belligerent. And so, of course, the defense don't want that in. They don't want him to be seen as somebody who flouts authority and who argues with the cops. But the judge said, no, that can go in because it's going to prove the identity of the person who owns the car. Now, that was one of the rulings that I thought was a little odd. Yeah, that paints him in a bad light. And just because he doesn't wear his seatbelt doesn't mean he's a murderer, and I understand that logically, but it doesn't paint him in a very good light. So that was one of the ones that I thought that could have gone the other way. All the other decisions, I've really agreed with the judge. The other thing that's happened is that there was a previous judge, and everything was filed under seal so that nobody could understand or nobody could find out what was going on in all these pre-trial motions. Judges said, enough of that. We want to have everything above board, accepting that they recently did a hearing that was closed to the public, and from the orders that came out of that, we believe that was the prosecution wanted to have him mentally assessed. Now, in Idaho, mental incapacity is not a defense to a crime. And so if you're not mentally competent, they won't put you on trial, because if you're not mentally competent to help your defense, they won't put you on trial. You need to be competent enough to aid your defense. But in most states, if you're mentally incompetent when you commit the crime, then you might spend a little bit of time in a mental hospital, but then you get a free pass. And in Idaho, I heard a prosecutor talking on a YouTube channel, and he said that defense had been used so much in so many inappropriate cases that the law was actually changed so that people couldn't escape responsibility by just saying, oh, you know, I had a bad mental day. So mental incompetence is not going to help him to be found not guilty. And so that's not what the question is about. The question is about the defense has put forward that Khoeburger has got autism. And so they're saying if he gets found guilty, then the fact that he's got autism shouldn't be an aggravating factor. I don't know how it would be an aggravating factor. Like if you've got autism, you're somehow more guilty or you more deserve the death penalty. I don't understand that argument. And I don't think the judge really understood that argument either. Grasping at straws. Anyway, the prosecution said, look, we're not going to use his autism against him. Okay, if he's found guilty, there's enough horror and actual real facts. We won't hold his autism against him. But then the defense turned around and said, well, he's got autism, so if he is found guilty, he shouldn't get the death penalty. Now, I understand the defense's job is to, A, have him found not guilty, but B, if he is found guilty, to try and save his life so that he doesn't get the death penalty. So that now they're grasping at straws and they're going, there was some other case that said it would be cruel and unusual to put somebody to death if they were mentally, the word, they used the R word, like not very bright, not very clever. We don't use that word anymore, but basically very, very low IQ and they couldn't understand, something like that. It would be cruel to put somebody with a low... So if you had an adult who had a mental age of a 6-year-old, for example, and they did something, it wouldn't be fair to put them to death, but they would still spend their life in jail or whatever other sentence the judge thought was fair. So basically they're saying, well, this case where they said if you have this low mental age or low mental capacity, they wouldn't put you to death. So he's got autism, which is suddenly now just this new diagnosis suddenly happened while he was in jail. Then he shouldn't be put to death. The real problem that they have with that argument, and this is what the judge said, listen, he was studying for a PhD. This guy is not stupid. He's not mentally impaired in the way that he can't function in the world or he doesn't understand the rules. Or in fact, he was studying criminology. He knew if he's the guy that did it, having autism is not going to save him. It's not going to be an excuse not for him not to face the punishment if that's the punishment they decide he needs to face. So the prosecution also wanted to have him tested to see about this autism, and the defense was saying, no, we don't want you to test him. And the judge said, listen, and this was the hearing that was closed to the public, but now we've got the result of. And the judge said, listen, you've had your experts, the defense experts, assess his mental capacity and autism and psychiatric whatever he might be going on with him. You can't now say that the prosecution can't also have their own experts evaluate him. So the judge is like, if you've got your own experts, it has to be fair. So he is going to be evaluated by the prosecution experts, but I'm not sure that it will really come into play because it's not going to affect the outcome. They can't say he's not culpable or not responsible for his own actions because of a mental defect, if autism is considered a mental defect. And I have people in my family who have autism, so I'm not saying that autism is a mental defect, but in the legal language, if it was found to be a legal defect, a mental defect, it still wouldn't save him from culpability, because remember, in Idaho, not having the right mental capacity doesn't mean you can be found not guilty. It's not a defense against the crime, but it might be mitigation as to how harsh your punishment should be. So I don't know. I don't know if they're going to go there with the autism. With the autism, they said that he had some other condition, which was a condition about, it's to do with coordination, something or other, deficit, which would mean that it would be impossible for him to have committed this very physical crime of stabbing to death 4 young people in the short frame of time. It's a very short frame of time, and they know this from seeing the car. and also there was a DoorDash delivery, so they know the time frame of it. And I think it was something like 13 minutes or something. It's 7 minutes or 13 minutes. It was a very short frame of time, and so the defense is trying to put forward, because he's got this coordination, whatever, he wouldn't have physically been able to do it. The problem that the defense faces, and again, the judge is going, really? The defense faces the problem is that he was actually quite a fit person, and he would go running at night, and he would run often on different routes. A lot of runners will run on the same route over and over and try and test themselves on their time, but he actually enjoyed the challenge of running different routes. And so if he is a fit young man and he can run, and he's got the coordination for running, he obviously has stamina and the ability to do physical things. And also the thing with the coordination developmental delay, I have a member of my family that had that, and it is a real thing. What it usually affects is fine motor coordination, so being able to write. Maybe that's why doctors write terribly, because maybe a lot of them got autism. Being able to like thread a needle, play with small Lego blocks, that kind of thing. It generally doesn't affect the gross motor coordination, your hands, your legs, although some people with autism find ball sports a little bit difficult because they've got depth perception issues. But usually it's a developmental delay. It doesn't mean forever and a day you are now physically disabled from this thing. So I think the defense were reaching at that one, and I think the judge was, I'm not sure what he ruled in the end. I think they can talk about it, but then, the other side can bring their own experts. So they got a bit quiet on that. Then I mentioned before that on the day of the morning after the murders, he had taken a selfie, and the selfie had the bushy eyebrows. The prosecution wants to put that in to show that that's what he looked like at that time. It was just a few short hours after the murders. So it's not like it's a class photo 3 months later where he's had chance to pluck his eyebrows or anything like that. It's not a time where there's been a delay and maybe he didn't have eyebrows on that day, but then they grew back. This shows at that time what he looked like, and bushy eyebrows. Now, of course, court judges already said the witness can talk about the bushy eyebrows, and she seemed to have had a fascination with eyes and eyebrows, because in her bedroom there were lots of drawings that she had done of eyes and eyebrows, different types of eyebrows. So anyway, so the defense didn't want this photograph in, and you've always got to wonder when the defense wants to keep something out, why are they so determined to keep it out? So firstly is the bushy eyebrows, because it's startling when you see him. But he's very pale, and his eyes are like really black, and he's very pale. Behind him you see his shower, and there's no shower curtain in the shower. And so there's some kind of theory that maybe he got rid of the shower curtain if it had evidence on it or something. When they did a search warrant, they were expecting to find the shower curtain. When they did it, there was no shower curtain. So it shows there's no shower curtain, so I don't know if that's going to be relevant. But he's there, he's doing a thumbs up, and he's got like a weird, creepy grin on his face, like he's so pleased with himself. It kind of looks like a trophy photo. Okay, look what I did. I am so pleased with myself. I've done this thing that I've been planning in my mind. That's just pure speculation, but that's how it can be seen. And that's why the defense obviously wants this thing kept out, because it does not look good. It just looks really creepy. And I don't really judge people on their appearances. I don't read that much into things, but this photo really is quite striking. Very striking. So the defense wanted to keep it out. Prosecution wanted to keep it in. Their excuse is that's how he looked just a few short hours after the murders, which sounds logical, but the creep factor is there as well, which obviously they can't put it in for that. And the defense counsel was saying, well, it doesn't prove anything. He took a shower and he did a selfie with a thumbs up. But anyway, judge said it can stay in because it does show his appearance just a few short hours after the murder, and it does show bushy eyebrows. So there you go. Defense failed on getting the selfie out. The defense also failed on another ground. She kept wanting to delay the trial, or she's complaining about the prosecutors providing her with too much information in a format that she couldn't, didn't have an index, that kind of thing. There was tons and hours and hours and hours of surveillance video, because obviously they were trying to find that car. Most of it is irrelevant, and she's just saying she hasn't had enough time to go through it all, and she's not going to be ready by the time of the trial, so she wants to have a delay. Or, oh no, I know what she was angling at. In the Lori Vallow Daybell case, when the prosecution took too long to give the defense certain evidence, this was also in Idaho, the judge decided to take the death penalty off the table in that case. So this is what the defense counsel here is hoping, by saying the prosecution took too long to give her the evidence, and it was too much, and we haven't had time to go through it all. She was hoping to get the death penalty taken off the table. But the judge was a bit unsympathetic. It's like, you asked for everything. You asked for everything. And so they've given you everything. And then the lawyer for the prosecution, they said, look, this is how we received the evidence. The stuff we got from the FBI has got an index in it, and we gave it to them exactly how we received it. We haven't gone through every single video either. We've looked at what we can, and we've pulled out the ones we think that are the most relevant. But, we can't say that there's nothing else in there that the defense might want to highlight at trial. We can't say that, and we can't run the defense's case for them. It's not our responsibility to find a defense for the defendant. And the judge agreed with the prosecution. The judge just said, look, you asked for everything, you got everything. Some of it is indexed. That's how it came. You kept pushing for everything. You got it all. There was also some suggestion that the prosecution had delayed passing the material on to the defense, and the judge said, look, that didn't happen at all. And then the main lawyer for Bryan Khoeburger said, oh, but I'm so busy, and my usual practice is to watch every single video and to read every single word on every single page, and there's just not enough time. And at some stage previously, she had been used a bit of hyperbole, and she had said, oh, it would take decades to go through. And the judge just said, I'm not giving you decades. You said it's going to take decades. And then she's going, no, I can do it before decades. No, decades are not really an accurate. He said, well, that's what you said to this court. So you need to find some way of handling this volume of evidence. You could have asked the court to pay for more legal assistance, more people to go through it, for a computer program an AI to sift through all the documentation. You could have done any of that stuff. And if you need it, just let us know. But we're not delaying the trial, and we're not taking death penalty off the table. So she kind of shot herself in the foot a bit there. Also, the judge noted that the defense lawyer had given notice to the court that she's taken on another death penalty case. And he said, this doesn't strike me as somebody who is overworked and doesn't have enough time to get this thing done, because now you've taken on another death penalty case. So clearly you've got enough time for two cases. You need to, work out your own time management, basically. And I think that's fair. I think that's fair. Clearly, she's just doing her job. She's just trying to get the death penalty off the table if he's found guilty. But yeah, no dice with that one. So now there was two other things that she argued. She said the prosecution should not be allowed to say the word murderer. So they're not supposed to say that he's the murderer. But after he's found guilty, if they're doing the penalty phase, then he technically is a murderer. So why would they not be allowed to call him the murderer once they're deciding how long he needs to stay in jail for, or if he's going to get the death penalty? So anyway, the judge just said, look, he's the defendant until he's found guilty, if he is found guilty. And if he is found guilty, they can call him the murderer. That's if the jury finds that he is the murderer, they can call him that. Okay, but they're not going to be calling him that in the normal course of the process, because he's not yet found guilty. He's got the presumption of innocence. So that was kind of a win, but it just seemed really weird. And then the other thing that the defense counsel also said is they don't want the prosecution calling their client a psychopath or a sociopath. And that was just really weird. I don't know where that came from, that they had to go to the court and get the court to make an order about what the prosecution could say. I have never ever in all my years heard any prosecutor calling somebody a psychopath or a sociopath, unless, of course, the person's been tested and found to have psychopathic tendencies, and they've got an expert witness to say that. And even then, you say psychopathic tendencies. You don't say psychopath. But anyway, I don't know why the defense counsel makes such an issue of this, and the judge just said to the prosecutor, "What is your reply before I make a decision on this?" And the prosecutor said, "We would never do that. It's not even something we would consider. Not even something that would be on our radar. We promise not to do that. We wouldn't have done it anyway, even if they hadn't asked. But if it's going to help them sleep at night, we won't do that." So they've agreed not to call him a psychopath. I don't know where that came from. Then there was the other issue about some of the students being creeped out by the defendant. They found him creepy. So these are the students, because he's studying for his doctorate. He was also a teaching assistant, so he had a class that he was teaching or doing tutorials with or something. And he found that some of the students found him to be quite creepy, apparently. According to, this is where the defense got this from. They got this from the interviews that the police did with some of the students. So obviously around the time of the crime, after they've identified this guy, they've gone and spoken to people who knew him, including some of his students, to find out more information about him. Did he say anything about the crime? Was he acting strangely around the time of the crime? And so some of the people, especially the woman, said that they found him a bit creepy and a bit off-putting, and so the defense is really concerned that this now is going to come up and it's going to paint him in a bad light. And the prosecutor just said, "We're not going to call any of those students as witnesses because they weren't there at the time of the crime, and just because they found him a little bit creepy or a little bit weird, a little bit off, that's not evidence as to whether or not he committed the crime. We've got his DNA on the knife sheath. You know, we've got the cell phone data. We've got him driving around that area repeatedly prior to the murder. We don't need these people to say that he was creepy, and so we're not going to call them." So I guess that was a win for the defense. But the prosecutor said, no, we wouldn't be doing that anyway. And then the final one that I want to talk to you about is motive. Now, you don't need to have motive. Don't have to have it to get a murder conviction. But it always makes it easier, I think, for the jury to find somebody guilty if you can present them with a motive. So there's been a lot of online speculation. Maybe he was obsessed with one of the girls. And then most recently, some journalist, I use that term loosely, some journalist came out with this theory that he had been in love with or obsessed with his professor, his very well-known professor in this field of psychopaths and serial killers, and she's written several books and everything. I'm not going to name her because this is totally unproven, wild speculation. And his view was that Bryan had this thing for her, had the hots for her, basically. And so his motive would have been to commit this perfect murder so that he could somehow be more attractive to this professor. Now, the professor wasn't the one he was studying under at the time the murders took place. It was the professor in his previous degree, that his undergraduate criminology degree. And then subsequent to this wild theory being put out there, one of the other aspects was this journalist said that this professor had been in email contact with him after he left studying with her, before the murders and again after the murders, and that she'd been advising his family about not pleading guilty or something. Anyway, so this professor came out and said, I've had nothing to do with this guy other than he was in my class and I taught him. We have not been in email contact. I have not been in touch with his family advising them about the case. When I heard that he was arrested, I did send a contact to the family. I think she emailed the parents, just out of courtesy, just showing concern. There was no relationship, nothing weird was happening. But the other thing is this journalist's theory, and to be fair, this was something that I thought. I thought he is so obsessed with serial killers, and he's so obsessed with this professor that it's kind of somehow weirdly linked together in his mind. But where the theory falls down is if he committed the perfect murder, nobody would knew that he did it. So she wouldn't know that he did it, so he wouldn't be more attractive to her. So it doesn't make any sense. Although if you're crazy and you kill 4 people, then what you do might not make sense anyway. So we don't know what the motive is, and I don't know if the prosecution is going to put forward any theories on motive. But you know, what is a motive to? And this is one of the things that the defense is saying. He had no motive to do this, so therefore he didn't do it. But sometimes we don't understand why people do things. With human nature is very strange, and yeah, I don't know. So I will keep you updated as we go on. The trial is going to start in August. It's a very sad, tragic case. My personal view, this is just my very, very personal view, the fact that they've got the DNA on the knife sheath, that for me is the smoking gun. The fact that his phone was turned off during those hours is also a very big red flag. And I just don't know how you can explain those two things away, especially if he wasn't in the usual habit of turning off his cell phone. It just sounds like a countermeasure. All the other things add up and add to it, but on their own wouldn't be convincing. You know, bushy eyebrows wouldn't be convincing. The car, even, we're not exactly sure if it's the same car, but it looks the same make and model probably. They never had the license plate. But the one thing that strikes me is none of the circumstantial evidence points away from him. Oh, the other thing is the Amazon. He bought the knife and the knife sheath, and then he went and put another knife sheath in his cart after the murders. That's also kind of really creepy. But none of the things point away from him. So if the photograph, the selfie, showed no eyebrows, then that would be maybe she got it wrong, or maybe it's really not him. Or if he had a bright blue car, then it would be, okay, we think it's the white car belongs to the killer, but he doesn't have a white car. Any of those things could have pointed away from him. His phone could have shown that he was at home that night. The security cameras at his building where he lived could have shown his car maybe not leaving the car park, but it did show him leaving the car park in the early hours of the morning. So all of the circumstantial evidence, although none of it actually points to him, my personal view is that he probably did do it, based on the evidence we have now. And I'm open to changing my mind, depending on what actually comes out in the trial. But based on the evidence we know now, my personal view is that he probably did do it. And I think that the state has a very good, strong case against him. And I think the defense is not going to have an easy time of it. And I think I don't know, it may have been strategically better to try and get a plea deal where he doesn't, where the death sentence is taken off the table. 2 issues with that. 1, he might not want to admit it. And 2 is that he might, what would the second one be? Oh, the prosecution might think they've got more than enough evidence, and they might not be happy to offer a plea deal. Also, they would have to have the permission of the family members, or they would take into account what the family members wanted. And I don't think any of the family members want a plea deal. Of course, it's a toss-up, because if he really did do it, and for some reason he's found not guilty, then he goes off scot-free. Or the other thing that kind of struck me as very, very odd, and you don't see it very often, was when he was first appeared in court. And you know how they say, these are the charges against you. How do you plead, guilty or not guilty? He did not speak. He had his lawyer stand up and say, my client stands silent. Now, that in its own doesn't mean he did it, but that's just weird, isn't it? I mean, I'm a true crime follower, And I can't even remember any other case that I've followed or any case that I've personally witnessed where the accused has decided to stand silent. And then when you stand silent, the judge then puts in a plea of not guilty on your behalf. So it is something that you can do, but it's just really weird. And I can't understand. I can't understand why he didn't say guilty or not guilty unless he doesn't want a recording of his voice to be out there. But there might be other recordings of his voice. Because that girl that saw him go past her, she actually heard somebody saying, don't worry, I'm here to help you or something. So maybe he was worried she could recognize his voice. I don't know. Just that's another thing that strikes me as weird. But people can be weird without being murderers. So that's not a reason to think that he's guilty. Anyway, thank you for following along. Do let me know in the comments what other cases you would like me to cover, whether they're old cases, newer cases, and what I like to do is provide you with the information, but then also provide you with my insights and sort of my views on the matter. And yeah, I look forward to seeing you in the next one.